not testimony, contention among members. So let me just say for the record, whenever anybody loses emails, there's always going to be a suspicion. So I just want to say that for the record. My concern was that nothing that Lois Lerner did, contemporaneous emails, and the question is, if you do lose, if you do crash, could I ask both of you, if you crash, if you're in the old IRS, because that's where these people are now, what should you do when you know that you may be called before a committee of Congress? What should you do when they tell you they couldn't retrieve your emails? What precautions should you take?
So what we counsel agencies to do is to make sure that IT, the legal counsel, and the records management and records officers are all working together on the different aspects of the Federal Records Act to make sure that records are identified and preserved and policies are being followed. If there were a crash of an individual's
and apparently
hard drive,
there have been a great number of crashes.
Yes. So a crash in and of itself doesn't necessarily mean that Federal records have been lost, but it does indicate that there are probably issues that need to be addressed with the IT organization, with the records organization, and with the
I'm now assuming the records have been lost. Now, obviously, that's catastrophic.
Yeah.
And somebody's going to be accused, as has occurred here, because there's hardly any way to prove that negative. So I want to know what precautions should be taken. They tell you your records are lost. It's a crash. What should be done? Because we may have this situation again, and now we know that the suspicion will come up. And I don't regard the suspicion as unfounded. I just think that the suspicion needs to be shown. So I need to know what you should do, since I don't see any way we can avoid this happening again until we get new software and new computers.
So the first step is to notify the National Archives that there's a problem so that we can start the process.
Do you know whether this was done in this case?
It was not done.
So that's the first thing, to notify the National Archives. Even before you try to retrieve it, just say, look, I've lost something, I want you to know it. Go ahead.
And we would, as we did in this case, when we found out, write a letter to the records manager there.
When did you find out in this case?
We found out when you did, that letter to Senators Biden and Hatch. And we submitted our letter 3 days later.
So what's the point of notifying you, just for credibility's sake? Is that it?
Well, no, because we're demanding that they investigate and report back to us in 30 days what's the situation. So that,
yeah, of course they were already doing that. So I mean, it must be for more than that. I mean, they weren't just sitting there.
This is the first indication we had that there was a problem. So we snap into action when we're notified.
But you were convinced that they were already trying to do that.
Well, what was going on at the time, it was clear that activity was going on. What was not clear to me until that letter appeared was that there were emails that potentially were not able to be reproduced and were lost. And that's the difference for us. There's a lot of activities that go on across the government every day to recover, crashed hard drives or other kinds of IT issues. But it becomes a serious concern of ours when it becomes increasingly clear that records may have been lost, and that's when we do get into action.
Well,
I think.
Yes, sir.
Go ahead. If the
I was
lady
going to
generally
say, when it becomes clear, I mean, it either is clear or not clear. It can't be increasingly clear. Someone has to look, and it may take some time. At the end of that search, then you can conclude it's lost or not lost.
you can answer if you would.
I actually wanted to make a couple of points related to this, if it was okay.
Sure.
When an individual in an agency should be working with their records officer to make sure that they're managing their records within the official record-keeping system. I am not familiar with too many official record-keeping systems that entail saving records on a hard drive to maintain them. You would do that for access purposes or reference purposes or things like that, but not as an official record-keeping system. So part of what we would counsel agencies to do is be in contact with your records officer, be in contact with your IT staff, be in contact with your counsel, so when these issues happen, you can figure out what needs to be done from a Federal Records Act perspective. Going forward with the directive and having agencies manage email in automated ways by the end of 2016 and pursuing capstone and other sorts of policy ideas that we have promulgated with the directive, we anticipate a day where we'll be able to remove human intervention from this sort of activity, and then
we now go to the gentleman from North Carolina, and for 5 minutes. I'd ask for just 10 seconds, if I may. Mr. Webster, would it be fair to say that when you should have been informed, if Lois Lerner knew that there could be Federal records on the lost drive, it would have been at the point that she discovered her drive was broken, and or at the point they were convinced they couldn't recover it? At that point, wouldn't it have come to the National Archives as, now you get to try to recover them if there are known to be Federal records on them? That would have been the time frame, is what I think I asked.
It would have been preferred for us to know about it when there was an issue that would have indicated that email was lost.
Right, and hundreds of other places where Lois Lerner could have helped you look for and find the records that would have existed in real time rather than years later.
The reason I'm having difficulty answering that question, it's more of an operational issue within the IRS as opposed to
but prompt reporting,
National Archives sort of issue.
Prompt reporting to you makes a difference.
Yes, because the prompt reporting to us allows the agency itself to be on notice to itself with our imprimatur that they need to take action.
Thank you.
Mr. Chairman, can I ask unanimous consent that the gentleman from North Carolina's
without objection,
reset
so ordered.
to 5? Thank you.
I thank the gentleman from Utah, and thank you, Ms. O'Connor. It's good to have you back. Good to see you again. In your testimony, you talked about when you got to the IRS on May of 2013, that all of Lois Lerner's emails were in this area to be redacted and worked on. Is that correct? That's what you.
They were still in the processing part where they were being flattened and decrypted, but they had been gathered already.
So they had all been gathered. Was there not anybody who looked and saw this huge hole between 2009 and 2011 and says, man, this is really strange that the email activity during this period, a lot of it disappeared? Was there anybody that looked at it like you would look, like Treasury would look at a counterfeit dollar and say, gosh, this is a fake? Was there not anybody that raised that concern?
So it wasn't brought to my attention,
would you be mad about that since you were overseeing that? Wouldn't you be mad if somebody saw that and didn't bring it to your attention?
if somebody had seen it, I would have hoped that it would have been brought to my attention.
So you think that somebody didn't see it?
I have no reason to think that anybody saw it and didn't tell me about it.
So you would be
Mr.
mad.
Chairman, could I ask the witness please to speak into the microphone? Ms. O'Connor?
Oh, Mr. Connor, can you move it
Yes,
closer?
If you
I'm
could
sorry.
speak in it, thank you.
Sorry about that.
So who is responsible for making sure that all the documents and materials are complete to submit to this committee or any other committee? Who is responsible to make sure that that body of work is complete?
I think it's probably the head of whichever agency has been asked for
And
this.
so we just trust them to make sure that it's complete. So there's no real oversight within the IRS to make sure that what we get is complete.
I mean, within the IRS, we had a whole number of different layers of sort of quality checking to make sure that the materials that were being reviewed were appropriately redacted and were then produced.
But there was no, all those layers, there was really nobody that was there saying, well, we've got everything we need.
The thing that I think is challenging about the situation is that I believe that the people who collected all of Ms. Lerner's material most likely believed they had it all because they got successfully what was on her hard drive. I think the missing piece was not knowing that there had been a crash.
So when they looked at, and they were going back to 2009, they didn't see that there was a whole big hole of where all of a sudden the email volume picked up in June of 2011 when she got her new hard drive. They wouldn't have seen just this unbelievable anomaly of additional emails.
So nobody brought it to my attention, and I
Okay,
didn't.
so let me go on a little bit further, because here's the bombshell in all of this. Every one of us have been counting on the TIGTA report for a chronological of who knows what when. Over 65% of what they reported were solely based on emails. So if we have a whole lot of emails that are missing, wouldn't that suggest that the whole TIGTA timeframe is at best incomplete?
So one of the things that I think is important in this is that my understanding is what the IRS has done is provided all the emails
But that's
from
after,
others.
that's after the TIGTA report. During the TIGTA report, what they reported, because this is new since then, wouldn't you agree that at best it is incomplete? Yes or no? You're a smart person. I've dealt with you before. Yes or no, wouldn't you agree that it would be incomplete?
I can't answer, and I can tell you why. The reason why is because my understanding of the TIGTA report is that it was based on interviews, extensive
It was
interviews.
based on 30% interviews, 65%. I've read the TIGTA report more. It's put me to sleep a number of times. So in that, if most of it's based on emails, wouldn't you say that if you didn't have all the emails, that the TIGTA report might not be the full story? It's a real easy answer.
If there were a
If there were
relevant email that was missing, then that might be true.
And
But
so
I
now
think
we know
the
that there are
material
thousands of emails that they never got to see from Lois Lerner, and maybe several others.
I'm not sure that we know that there are thousands
Okay.
that we have.
All right. So let me go on very quickly to my good friend there with the National Archives, and I say that in a sincere fashion. Now that we found last night that not only is it Lois Lerner's hard drive, but it's a number of other people at the IRS, do they call you on a regular basis to say, listen, we may have this problem? Have you gotten a number of notifications from those higher officials that have had hard drive issues?
Not to date.
Neither of you?
No.
So we have a federal law that is being ignored by the IRS. I'll yield back.
Thank the gentleman. Now I recognize the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you, Mr. Chairman. And let me provide a recent history lesson to my colleagues. During the administration of President Bush, government officials lost millions of emails, including significant numbers of White House emails in the midst of congressional and criminal investigations. In one instance, the Bush administration lost nearly 5 million emails related to various White House matters under investigation by Congress. At the time, a White House spokesman stated, quote, "We screwed up and we're trying to fix it." Mr. Ferriero, your predecessor, Alan Weinstein, wrote to the White House counsel at the time, Fred Fielding, and said this: "It is essential that the White House move with the utmost dispatch, both in assessing any problems that may exist with preserving email and in taking whatever action may be necessary to restore any missing email." Those Bush-era documents were also pertinent to criminal and congressional investigations. In 2006, Special Prosecutor Patrick Fitzgerald hit a roadblock when emails relating to the Valerie Plame leak investigation went missing. Fitzgerald explained, and I quote, "Not all email of the Office of the Vice President and the Executive Office of the President for certain time periods in 2003 was preserved through the normal archiving process on the White House computer system. In 2009, the Department of Justice investigated a so-called torture memo, but one key Bush administration official's relevant emails had been, quote, deleted and reportedly were not recoverable." Mr. Ferriero, I understand that you were not the archivist in the previous administration, but I assume you agree that the IRS is not the only agency to have lost emails related to congressional investigations. Is that correct?
That's correct.
And I assume you also agree that the Federal Government has had significant and long-standing challenges with records retention, especially that of emails. Is that
From the very beginning of the government.
from the very beginning? of us using emails.
And using paper. This is not just an email problem. This is a records management problem.
And according to the General Counsel of the Archives at the time, the archivist's request to the Bush White House went largely ignored. My, what how a few years changes things. You know, the General Counsel reported that the National Archives knew, quote, virtually nothing about the status of the alleged missing White House emails. Mr. Ferriero, can you discuss some of the policy changes President Obama has made to improve records retention throughout the Federal government?
As I described earlier, he's issued a memorandum on records management, the first time since the Truman administration that the White House has gotten involved, recognized an issue around records management, and authorized the creation of a directive by the Office of Management and Budget and myself that went to all the agencies, outlining what we need to do to get our act together, as well as a set of promises about how the archives was going to support that work, involving industry partners in creating new tools, creating more visibility, credibility within all of the agencies around records management, professionalizing records management across the government, doing a better job of training every member of the Federal government in terms of their records responsibilities. So there's been a huge focus on records management.
So you have seen a change in how IT managers at the different agencies archive.
There's been a great deal of interest, support, and collaboration for the first time that I can see between the records management community and the CIO community in the Federal government.
And do you believe that President Obama has made retention of these records a priority of his administration?
The administration certainly understands the problem and has authorized the direction for us to implement new ways of solving this problem.
Thank you.
Would my friend yield for a question?
Gentleman's time has expired.
I would ask the Chair for a little leeway, given the fact that the Chair of the full committee has many times been granted
And I've been patient.
time throughout this hearing.
All morning.
I simply have a question for my colleague, if the Chair would allow it.
Proceed.
I thank the Chair. Is it not true, you brought up the Bush administration experience, is it not true that many of the 5 million emails that were lost that you described were in fact deleted? It wasn't because of crashed computers. They were actually deleted.
Sure, intentionally deleted.
Intentionally
in
deleted.
order to hide whatever it is they didn't want the public to see.
I thank my friend.
Out of the Vice President's office of all places.
I thank my friend. I thank the Chair for his courtesy.
Gentleman's time has
I yield
expired. We
back.
now recognize the gentleman from Pennsylvania, Mr. Meehan, for 5 minutes.
I thank the Chairman and remind my colleagues, Mr. Fitzgerald was a colleague of mine. There were people that were investigated and convicted as a result of that matter. We have gone a long way in this without even getting close to that particular issue. Ms. O'Connor, I have great respect for your history as an attorney, and you yourself have identified that you manage complex litigation matters before you came here. So I'm asking for some of your insight, even though this may have been prior to your actual involvement. But in June early in June 2011, in fact, June 3rd, Ways and Means Chairman Dave Camp sent a letter to Doug Shulman, the Commissioner, in which he identified alleged discriminatory practices on the part of the IRS, very specifically. From your perspective, when somebody alleges discrimination, do you think that there's ever a chance that that matter gets to litigation?
Allegations of discrimination do sometimes get to litigation, yes.
Yeah, so they do sometimes get to litigation, don't they?
Mr. Chairman, could I please
around
could I please
around
just ask the
2000
witness
no,
to speak into the microphone?
Okay,
I'm very sorry, sir.
I'm sorry. Around 2011, in fact, very similar to the same time, there were a series. There had only been 2,000 pages of responsive materials when these original requests had come in. Only 2,000 pages, but hundreds of those 2,000 pages that came from the IRS were materials and emails that were purportedly showing that the efforts were being directed not just to conservative organizations, but at liberal organizations as well. So we have, in my mind, a very responsive body on the part parsing the materials that are being returned in response to a Ways and Means subpoena. So knowing that there are discriminatory allegations and knowing that the IRS and those who are advising the IRS in the very limited return are using great degrees of discretion in the form of the materials they are returning, how do you comport with the responsibility under the law of what is emails which may be subject to electronic discovery? This is not ambiguous. Certain electronic records may need to be identified and preserved when litigation is anticipated. Why was there not an effort undertaken on the part of people to preserve those records as far back as 2011?
Which records in particular?
The records of Lois Lerner, and she was advised in January of 2011 very specifically that her communications were potentially the subject of discriminatory practices. And by your own admission, there is a recognition that those emails may be subject to litigation by the requirements in preparation for litigation. As an attorney, I used to receive those. You are required to maintain those. Why weren't those emails retained in 2011 when she had noticed that she was potentially subject to discriminatory practices?
I don't know. I wasn't at the agency then.
Well, I do have a question about that, and that's one of the problems, because it appears that that also happens to be just the same time frame, within weeks in June 2011 that 7 people from IRS had their computers crash. Pardon me for being suspicious about the timing. Now, in terms of response, and response to emails that have actually been sent to us here, well, I'm sorry, my time has expired. I had one more follow-up question, but I'm not going to be able to get to it.
You still have 15 seconds. Go ahead.
Yeah, I need a document. Oh, wait a second. I have it. I have it right here. The question is responding to all emails. There have been numerous requests from this committee and others for all of Lois Lerner's emails. And yet, in a letter that just came only probably a week or two ago, we have the IRS telling us that fulfilling the request would require that you go beyond the search terms that were originally loaded for review. So let me ask, why are there search terms for emails when every email is being requested? And this is only weeks ago that we're finding this response. What is ambiguous about every Lerner email?
So I believe all of the, I don't know if it's all, but many of the pieces of correspondence that accompanied the documents that were produced referred to the fact that they were produced according to the terms that we had talked with your staff and other staffs about, the committee staff. I mean, there were 4 different committees doing investigations. We met with all 4 staffs, asked them to provide search terms. The staff of this committee provided many of those terms.
But you're saying it was their responsibility. What's ambiguous about the word all?
Gentleman's time. Sorry, the gentleman's time has expired. You may complete your answer, Ms.
The reason that in any large document production, search terms are applied is that it enables the people who are seeking the material to get what they want faster. That's the reason for the use of search terms.
Gentleman from Virginia, Mr. Conley is now recognized for 5 minutes.
I thank the Chair. Mr. Ferriero, there are 90,000 employees in the IRS. Is that correct, to your knowledge?
To the best of my knowledge,
How many of them have computers?
I have no idea.
Mr. Wester, any guess?
I do not have one either.
Do you know how many computers? We had testimony last night from Commissioner Koskinen. So far this year, and it's only June, 3,000 IRS computers have already crashed. Were you aware of that fact?
From the testimony last night, yes.
So that's a pretty high percentage. Well, let's assume therefore, if we stay on that trajectory, we're going to have 12,000 computers crash in the IRS alone, right? If you double the number? Excuse me, 6,000. 6,000. That's a pretty high percentage every year of, if you assume 90,000 computers, the maximum number. That's a lot. My friend from Pennsylvania sees some conspiracy. It's just coincidental that right after her computer crash, Lois Lerner, 7 people in Cincinnati go rogue on us and create bolos that seem to be nefarious. But the fact of the matter is there's no evidence that because of one thing happening in Cincinnati, it is related. I mean, that's a logical fallacy that is taught in law schools and in logic courses. The two are not necessarily related. In fact, there's no evidence the two are related unless one wants to treat Lois Lerner's computer crashing as a unique event in the IRS, which is indisputably not true. Would you agree with that, Mr. Ferriero?
I agree with that.
And this isn't unique to the IRS, is it? I mean, we're dealing with an aging set of IT investments in the Federal Government because we don't keep up with investment. The Chairman and I, Chairman Issa, have introduced a bill, FITARA, the Federal Information Technology Acquisition Reform Act, a mouthful, otherwise known as Issa Connolly, which, thank God, is being marked up this week in the Senate, passed the House 3 times unanimously. And it is designed to try to upgrade our investments. We spend $82 billion a year in IT investments. $20 billion at least is inefficiently used for just maintenance of legacy systems. That's got to be of enormous concern. And if Congress wants to do something about it, wouldn't it be a wise thing to try to make some prudent and targeted investments, Mr. Ferriero, so we're not dealing with this kind of issue?
It sure would, and you'd have a lot of friends in both the CIO and records management community if this gets passed.
Right. Now, I heard you say earlier that the Federal Records Act requires print and save as the policy.
And I misspoke. It doesn't, that language is actually not in the law, but that's the guidance that many agencies are following.
All right. So based on that law, some guidance was issued that says, at least for now, print and save. I assume the reason for that guidance is because with antiquated systems, we don't want to take the risk of backup that could crash.
Well, actually, the guidance came before electronic mail was even.
Oh, so we haven't even updated it.
That's right.
Right.
That's right.
Yes, the guidance issue precedes the IT problem.
Well, Lord Almighty.
Which is why EMPA is very important to get that passed.
Yeah. By the way, why not use the cloud? I mean, our legislation would consolidate data centers throughout the Federal family. Why not move to the cloud? Do you have security concerns, Mr. Ferriero, with respect to the cloud, such that we shouldn't do that as an alternative to paper backup?
We are using the cloud in the National Archives. We're using the Federal cloud.
Because we heard from Mr. Koskinen last night that he was a little concerned about security, and I understand that concern, but one could make the argument, especially after the Lois Lerner computer crash, that actually security might be better in the cloud, in the private sector managed cloud, than frankly relying on these old, cranky, obsolete, hard-to-maintain systems in the Federal Government. Mr. Wester?
I would say that the 6103 issues that were brought up last night are very serious concerns, and we have them as well for IRS records that we work with the IRS to maintain and provide access to. But your point is well taken that, and it's actually one of the items within the directive to move the Federal Government to the cloud and ensure that as the agencies move to the cloud, that effective records management policies and practices are implemented.
I just want to say, Mr. Chairman, in closing, and I thank the Chair for his indulgence, I understand some who want to pursue a conspiracy theory and try to use an isolated, well, not such an isolated event, the crash of a computer at IRS, and ascribe to it all kinds of nefarious reasons. I prefer to say, from an IT perspective, frankly, unfortunately, this is par for the course. This is what happens when we allow the degradation of our IT investments throughout the Federal Government, and I don't know how we can be surprised. And the fact that there were 3,000 computer crashes already this year in one agency, the IRS, I think makes the point that sadly what happened to Lois Lerner's computer is hardly unique. I thank the Chair.
Thank the gentleman. Now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Mr. Archivist, I want to thank you again for coming to South Carolina. You were and remain a big hit with everyone who had a chance to hear you, and I've had a number of people ask that you come back to South Carolina and that I not come back to South Carolina. So with respect to the retention of documents, can you give us, not as an expert, just 35,000-foot level, why is it important that we as a republic retain documents?
So the American people can, that the American people can hold their government accountable, so that they can see for themselves how decisions were made, so that they can learn themselves from the original documents about our history?
Right. There strikes me that there's a historical component, there's a constitutional component, so you can have checks on the separation of powers, and there's also a legal component. And you were gracious enough to brag about not being a lawyer earlier. We have an expert lawyer sitting beside you, so I'm going to ask Ms. O'Connor what spoliation of evidence is.
So I encountered that once in a case, and what happened was that after the case had begun, somebody who worked for one of the parties, without realizing the material was supposed to have been kept, destroyed it, burned it is what happened, and then it wasn't available for the trial. And
right, and from an evidentiary standpoint, what happens? There's a presumption that whatever you destroyed or altered would not have been good for you, right?
So the judge had to go through an effort of evaluating whether or not there should be a negative inference from that.
Well, the jury can decide that. The judge decides whether or not to charge that, but the jury ultimately determines whether or not to draw that inference. And it's important for us to know that the reason we have that spoliation of evidence in the law is so that people don't destroy evidence that would not be favorable to them. I mean, it's commonsensical. If you can get away with destroying evidence that's not favorable to you, everyone would do it. So we have to have a presumption built in. And with respect to my colleague, the former United States Attorney from Pennsylvania, you talked about search terms. I got to be candid with you. I don't know what search term you would use if you're looking for an email where Lois Lerner responds, "You who," when somebody says a Democrat beat a Republican the night before. What search term would you recommend?
So I haven't looked at them in a while, but I'm pretty sure Democrat and Republican were on the list. So that
but what if Democrat and Republican weren't in the email? What if they used the name of the Democrat who beat the name of the Republican and her response was "You who"?
So most of the terms came from the majority staff of this committee and included many politicians.
But what's wrong with the search terms being to and from?
Well, that would get you everything.
Right, that's my point.
The purpose of reducing the amount to review in order to get
But why? Why reduce it? If you want access to all of the information, if you want access to all of the truth, why are you reducing the search terms? Why not just to Lois Lerner and from Lois Lerner?
Right. As I explained earlier, I can't remember if you were here, at the beginning of the project, we met with the staffs of the four committees.
Right, and it's important to note that that was your request to meet with them because you thought the original request was too voluminous. And my response is, when any administration, Republican, Democrat, Whig, Bull Moose, don't care, but when you come to a committee of Congress and you try to negotiate a reduction in the search terms because of time constraints or resources, and this happens, let me tell you, the next subpoena you're going to get is going to be simply to and from, and you can save yourself a trip to come over and try to negotiate the terms. It was done to make life easier for you, not for Congress. Agreed?
Honestly, it was done in order to get you the material you wanted faster.
Well, it didn't wind up happening, so shame on us if we let it happen again. What negative inference would you draw from the failure to retain the documents in this particular case?
You're talking about Ms. Lerner's hard drive crash?
No, what I'm talking about is the failure to retain, whatever the mechanism of the failure, whether it's intentional or just negligent. You have someone who said maybe the FEC will save the day. You have someone who said we need a project, but we need to make sure it's not per se political, and then the emails disappear. What negative inference would you draw if you were just one of our fellow citizens watching this? You know that initially there was a denial of targeting. You know that she picked a very obscure ABA conference to disclose that targeting had taken place. You know that initially it was blamed on 2 rogue agents. In fact, Jay Carney perpetuated that myth. You know that Lois Lerner took the Fifth Amendment. You know that the President of the United States said there's not a smidgen of corruption. And now you're told that the evidence doesn't exist. Emails don't exist. What negative inference? If you were just a regular citizen sitting at home watching this, and you've got that litany of failed defenses, those false exculpatory statements, and now you're told that evidence doesn't exist, what negative inference would you draw?
One of the things that I found instructive in the material that became public in the last week was that Ms. Lerner had sent her hard drive to the Criminal Investigative Unit for them to attempt to recover it. And the inference that I would draw is that if she wanted intentionally to destroy the material, she would not have sent it to the Criminal Investigative Unit.
Did she ever use her personal computer?
I don't know.
She did.
The gentleman's time has expired. Now recognize the gentleman from Vermont, Mr. Welch, for 5 minutes.
Thank you very much. Thank you, Mr. Chairman. A couple of things. First of all, I want to thank you all for being here, subpoena or not. Appreciate the work that you do. Second, I want to say a couple of things. One is, I am a strong supporter of congressional oversight, and I do believe that when Congress requests information, it should be provided. But I have some significant concerns about the way we've proceeded on this hearing. When you go back to the basics here, there is a very serious question about what happened to the emails, and we're investigating that. The IG has investigated that. But there's also a very serious question about the abuse of the 501c4 status. And that, in my view, is a worthy topic of investigation. No group should be targeted because of their political affiliation, whether they're conservative or liberal. I totally agree with that. But no one should be allowed to abuse the 501c4 status. That's worthy, in my view, of investigation. It's not a tax exemption, as Mr. Issa mentioned, but it's a way of funneling money under the cover of doing social welfare work, which is really about political advocacy. And political advocacy is fine, but do it in the daylight, not in the dark. And don't undercut the merits and the legitimacy of 501c4 social welfare organizations by turning them into political operations. And frankly, I'd like to see our committee giving equal weight to that investigation. This dark money that's going into politics, in my view, is really pernicious for democracy. And it's terrible if we have any agency of government that's not providing requested information. There's always a fair question if there's been a computer crash, how did that happen? Was it intentional? But there's also this fundamental question about the money in politics and the use of the 501c4 organizations by liberal or conservative groups basically to hide the money that's going into political advocacy. The second thing, Mr. Chairman, is that, yes, we have to examine these questions, but I do not think that jumping to conclusions and assuming the worst possible interpretation is a way to, A, give respect to folks who dedicate their lives to public service, whether it's in the IRS or any other agency, and B, any way to educate the American people about what the problems may be in an organization, because the whole point of accuse first and examine facts second is to attack the very legitimacy of the organization that's being investigated. And I'd point out that when you lose information, it does raise a question. But I know Mr. Isar, Chairman, during the Bush administration, had to explain that oftentimes that can happen with computers. Was it innocent? Was it deliberate? We don't know. And one suggestion, talking to Mr. Lynch, who may discuss this, why not have the AG take a look at this? Why not have the IG do it? You know, we've got a partisan situation going on here that's getting in our way of getting to, I think, what is a shared goal of getting to the bottom of the
Would the gentleman yield?
I will yield.
This won't surprise you. The way this investigation started is I went to the IG, TIGTA, because they had the ability to look at 6103, and we were interested, and they began that investigation. One of the problems is the IG was never given that drive, nor were any entities independent and outside the IRS, which is, you know, one of the reasons that as an IT background guy, I've never seen a disk drive that has 0 left on it.
Well, I'll reclaim my time. Thank you. And I thought that was a good move on your part. I think we're getting a little bit off the rails now, because I think if we got the IG to look into this question, where essentially there's a motivation issue that both sides without the facts can come to their own conclusions, and usually we all come to conclusions that suit our political bias, I think it just creates a swamp. You know, in this function that we have in this committee, Mr. Rice, as you know, and I appreciate your aggression, but there's got to be, in my view, a balance where, yes, we investigate real hard, but it doesn't so overwhelm that this fundamental question about the 501c4 abuse, in my view, suddenly is not an issue. I mean, I was one of the people who was concerned and wrote a letter to the IRS saying, what's going on? Do your job. Investigate. And, you know, there's no free ride around here. If you're a taxpayer and you're not paying your taxes, I think the IRS should investigate you. I think if you're a 501c4 organization and you're essentially a cover for a liberal or conservative political ideology and you're not doing social welfare work, you should lose your 501c4 investigation. And thank you, Mr. Issa, for doing that with the IG initially, and I'd like to see us get back on track here, and maybe they can help us out with this specific question that we're dealing with now, and I yield back.
I thank the gentleman. I'll now recognize myself for 5 minutes. Ms. O'Connor, the IG, the Inspector General, issued their report on May 14, 2013. You were then appointed, I believe, on May 30th of 2013. What did you do? What's the first thing you do when you walk onto this new role?
I got a badge. I had some training. I think the 6103 training.
No, but how did you organize? Who did you bring into the room and say, all right, we need to move forward, this is what I got to do? Who do you bring into the room at that point?
Well, it wasn't like that. I mean, it really was, the first and most important thing was the 6103 training, because
okay, so after you got trained, then what did you do?
And then I believe I met with Mr. Werfel to see kind of what was on the plate and what the marching
okay, after that, yeah.
I can't remember the sort of play-by-play, honestly.
Who did you gather around you to get your job done?
I didn't gather anybody around me to get my job done.
There was nobody, you just did it all by yourself?
No. I mean, my job, as I explained earlier, was to advise the Commissioner on a variety of things. One of the things that I did was to work with a team that was fairly small at that time, but got very large later.
Who was on that team?
It's a whole number of IRS people, and it changed.
Go ahead and start with somebody. I'd like a list, please.
I think the best way to get you accurate information on that would be to ask the IRS.
No, I'm asking you. You were the IRS at that point. You were the person in the room that they were reporting to. So you come with great title. Tell me who you were interacting with.
The team had some 6103 experts on it. It had some tax litigators on it.
Who? Name a person. I want actual names.
Honestly, I would like to be able to have accurate and complete testimony, and it's going to be hard for me to recreate it. I mean, I was just
Can you name
last
even
night.
one person that you interacted with?
Well, I certainly interacted with Mr. Werfel quite a lot.
Okay. Mr. Werfel. Who else?
Mr. Wilkins was the chief counsel, and I interacted with him.
We assume that. Those are the people you reported to. I want to talk about who reported to you. Name some people that reported to you.
I think that the best way to do it is to get
I know, but you're here in front of Congress. You knew this was going to happen. Name one person that you interacted with.
I interact with a lot of people. Nobody
I know you
reported
did a lot of people. Name somebody.
who I interacted with.
Yes.
The Deputy Chief Counsel, Chris Sterner.
Chris Stern. Anybody in the IT arena?
I didn't actually interact directly with people in the IT arena. There was somebody whose name was, I can't even remember his last name. I think his first name may have been Ben.
So a guy named Ben, a dude named Ben. Who else?
I don't recall.
You were there 6 months. You had people around you that would jump at your very presence. Who are these people?
Nobody ever jumped at my very presence. I can assure you of that.
I'd like to ask them that. Who are these people?
Again, I didn't interact with the IT staff very much.
You were there 6 months. You had some people reporting to you, did you not?
I didn't have any direct reports, no.
Did you have people that were responsive that you asked questions of?
On any variety of issues.
Who did you
yeah.
ask questions of?
I worked with a lot of people in the Chief Counsel's office. If we could get
Ms.
I'm
O'Connor,
sure we
you're a
could get
very
your
bright
card.
person. You're very bright. You're very personable person. Why are you being so elusive? Why not just tell us who you asked questions of? Who interacted with you? You haven't named a single person.
I named Deputy Chief Counsel.
You named 3 people that you report to. I want to hear people that you asked questions to that ran, got the information, and then came back and gave you information. Name one person in that category.
People who I asked questions of who ran and got me the information. I don't even think I can characterize anybody that way.
Do you ever ask anybody in the IRS to provide you information?
Sure, yes.
Give me one example.
In the tax-exempt organization, the person who replaced Ms. Lerner, whose name is Ken Corbin, was somebody who I would call to ask for information about how the unit was working and
Okay, there's
information
one.
questions about
How
that sort of
many
thing.
people do you think you asked information of?
Probably a lot of people.
Can you name more than one?
I've named a couple now.
Why are you being so elusive?
I'm not being elusive. I haven't been there for a
How long
while.
would it take you to get that information and provide that information to me?
The IRS can provide that information to you.
Why can't you provide that information?
Because I'm not there anymore, and I don't have any records from when I was there.
Mr. Chairman,
Yes.
you know, I think you may be unfair to the witness. The fact is that last night the Commissioner could not remember 60 days ago who told him about the importance of losing those documents. Last night he could not narrow 60 days, less than 60 days ago, within 30 days when he was told. I think that, in fact, the ability to remember at the IRS is simply limited.
Do you know Thomas Kane?
I do.
Who's that?
I think his title was Associate Deputy Chief Counsel.
And you did interact with him.
I did.
I think my time's expired here, and in deference to what this committee does, I can't believe that you're not more candid with us and just telling us who you interacted with. It's a simple, easy question. It's hard to believe that it took 5 minutes to try to extract out a dude named Ben and one other person. I yield back. We'll now recognize the gentleman from Massachusetts, Mr. Lynch. 5 minutes.
Thank you, Mr. Chairman. I think sometimes the search for conspiracy is interfering with the meaningful oversight that we should be doing. I think sometimes my colleagues on the other side of the aisle are just reaching for the most grandiose conspiracy theory and forgetting that we do have some evidence of wrongdoing here that we should be going after. And I want to try to refocus on that. In spite of all the conspiracy allegations, there is some evidence here before us, and I've been hearing from some of my colleagues on this side of the aisle that there's no evidence of wrongdoing. And look, I'm not here to make excuses for the IRS. I'm not here to protect the IRS or to downplay what they've done here. But let me try to refocus here. There was serious wrongdoing on the part of the IRS here. There's evidence that they used improper search terms. They used quote-unquote Tea Party search terms, Patriot search terms. If you had a complaint in your file about government spending or taxation, or if your case file in applying for 501c4 status included statements that criticized how the government was run, the IRS targeted you. The IRS also asked for inappropriate information. They asked for the names of donors. They asked for the list of issues that the applicant cared about and what their positions were on those issues. They asked whether the applicant or officer intended to run for office. They asked the political affiliation of the applicant for the 501c4. Now, Ms. O'Connor, are you aware, I know you weren't at the IRS when this analysis was going on, but you went there later, and also I think you might have been in on some of the interviews we had with some witnesses from the IRS. Are you aware of an IRS BOLO, be on the lookout, listing for groups with progressive in their name?
Yes.
Okay. Are you aware of evidence that the IRS employees treated progressive organizations in a similar manner as conservative groups?
Certain, yes.
Okay. I ask unanimous consent. We actually have a report here of the IRS entitled, "Inappropriate Criteria Were Used to Identify Tax Applicants for Review." And we also have a letter here from Acting Commissioner Werfel that indicates the progressive groups that were also targeted. I ask unanimous consent that they be entered into the record.
Without objection, so ordered. I would also ask for unanimous consent to enter the report from the majority staff debunking the myth that the IRS targeted progressives.
My information is more recent and is completely accurate, and it includes a disavowal by the Inspector General of your report, which he testified in.
I would stand behind the accuracy of this report as well. I'm just saying we're going to enter this in the record, and you're going to enter yours in the record. And God bless America.
Let them fight it out.
All right, thank you.
All right. The IRS subsequently released information that the IRS targeted Emerge America, Acorn affiliated group. Now, look, I'm not saying this to mitigate the wrongdoing or the misconduct of the IRS. This makes it worse. It makes it worse that the IRS was actually violating the constitutional rights of progressive groups and conservative groups. This is wrongdoing. It doesn't help the conspiracy theorists, but it certainly indicates wrongdoing, serious misconduct on the part of the IRS, probably our nation's most powerful agency. It's got information on health care, finances, knows everything about you. So they're violating the free speech of our citizens, violating the freedom of association of our citizens, violating the freedom to petition the government of our citizens, and violating I think, constitutional right against search and seizure because of the way they're conducting themselves. And this isn't just evidence. The IRS has stipulated this in their report. They said, yeah, we did this. So we have some serious wrongdoing. And now, in pursuing the evidence of that wrongdoing, we have 27 months of emails disappear. And I'm asking you, how do we restore the trust in this? How do we pursue this in a way that, look, I'm not going after President Obama here, but I am going against the IRS because of their misconduct. And that's the thing we're overlooking here. In going for this grand conspiracy theory, you're overlooking the stipulated fact that the IRS conducted misconduct here. And I think we're missing what we should truly be going after. Can you suggest what we should be doing, any of the witnesses here, in terms of getting to the bottom of this, getting to the IRS misconduct?
Witnesses, if someone wants to respond, great. If not, we'll move to our next.
Okay. That's great. Thank you.
I thank the gentleman. The gentleman from Ohio is recognized.
Thank you. I appreciate Mr. Lynch's statements that this was wrongdoing and misconduct. The issue that we have that we're all struggling with, which is how Mr. Lynch ended his question, is, well, what do you do to pursue that wrongdoing and misconduct? I mean, we're still sitting here without a complete understanding of the basics of an investigation, which are who, what, when, where. Everybody knows the 4 Ws, who, what, when, where. And we know that the missing emails in part thwart the ability to complete that story, as it also has included Ms. Lerner's failure to willingly testify before this committee. I'm going to put all that aside for a second. Ms. O'Connor, you're White House counsel. I'm a lawyer, you're a lawyer. I want to step away from the IRS problem and investigation for a minute and just have a comparative discussion, because I think in the responses there may be some misunderstanding with respect to the independent, the Treasury Inspector General for Tax Administration, and I'd like to talk to you a minute about their powers. Not with the IRS, but just in general. I'd like to compare the powers of the Treasury Inspector General for Tax Administration with the FBI. Because one of the things that we heard from the Commissioner yesterday is, well, we're going to do, the Inspector General is going to do an investigation. That is probably a good thing. There are many who don't believe it's enough. But you and I, having a discussion on a comparative just of authority and powers, perhaps can let other people decide whether or not that's sufficient investigation or whether an additional investigation needs to be undertaken. So let's just talk about the Inspector General and the FBI. The Inspector General's mission statement is that they were established under the IRS Restructuring and Reform Act to provide independent oversight of IRS activities. They promote the economy, efficiency, and effectiveness in the administration of the Internal Revenue laws. It is committed to the prevention and detection of fraud, waste, and abuse within the IRS. The Department of Justice says the FBI includes upholding and enforcing criminal laws of the United States. Pretty big distinction. So let's go down with some of those powers, because the FBI is involved in criminal investigations, and the Inspector General is involved in internal investigations in the FBI, excuse me, in the IRS. We give them different powers. Let's go over some of those. Now, the Inspector General does not have the ability to compel people to testify outside of the IRS. Isn't that correct?
I believe that's correct.
The FBI does, correct?
Yes.
Yes. So when the Inspector General undertakes an investigation of the IRS, they're only going to be able to interview those people that are there. Only the people at the IRS are the only ones that they can compel to testify. If there's somebody outside the IRS who may have been involved or have information about it, the Inspector General falls short, doesn't have the ability to do that. They can't even do that with respect to contractors. So when people say the IG is doing an investigation, it's not the same. Let's go to another one. The IG doesn't have the ability to arrest anybody, right?
So I want to be helpful, but I'm not an expert in the IG Act.
But you know the IG cannot go and arrest someone, right? You're a lawyer, I'm a lawyer, Ms. O'Connor, you know this. You're the White House General Counsel. They wouldn't hire you unless you knew this basic. The 5 things I'm going to ask you are real basic, simple comparatives. The IG cannot go arrest someone, right?
I trust what you're saying, but I haven't reviewed the IG Act. I actually
well, we both know the FBI can, correct?
Yes.
Okay, excellent. Warrants. The IG does not have an ability to execute a warrant. The FBI does. So the difference here is that the FBI can go seize things where the Inspector General has to request them, like we do, and ask for things to be delivered to them. So the FBI can actually go in and take hard drives and take materials that could lead them to an investigation. The IG is in a responsive or requesting mode. A subpoena power. Again, the IG has that, but only of Treasury employees. The FBI, as you'll agree, the FBI can subpoena anybody who's relevant to the investigation, right?
Yes.
Okay. So the issue that we have here is when people say, well, we are doing an investigation, the IG is doing an investigation, you and I can agree it's not the same type of investigation the FBI would do. And the FBI's mission is enforcing the criminal laws of the United States. And as you know, and as Mr. Lynch was saying, the concern that people have of this wrongdoing and misconduct is that perhaps a law was broken. Now, if you're going to do a criminal investigation, wouldn't you agree that the FBI is the one that should be doing a criminal investigation versus the IG?
So
and I'm not talking about the IRS, just in general. Just come with me on the issue of just in general. If you have a criminal investigation and you're the White House counsel, Ms. O'Connor, do you assign that to an Inspector General or do you assign that to the FBI? Where would you put that as an attorney?
My understanding of the situation here is that
No, we're not in the situation here. I'm saying if there's a criminal matter and you're assigning it, do you assign it to an IG or the FBI? Come on, you can give me this one. You would give it to the FBI, right?
I recall when I was at the IRS that the IG had a number of deputies, one of whom was his deputy for investigations. They seem to be very hardworking.
I'm certain they're incredibly competent people, but by law, they're limited in their investigative powers, and the scope that they're given of their mission is not the scope we gave the FBI. We don't need 5 FBIs. So wouldn't you agree that if there's a criminal matter, you wouldn't choose the IG, you'd choose the FBI?
If the matter is what happened to a laptop within the
No, I'm not asking your opinion on this matter, just criminal. I'll tell you what, it belongs in the FBI. The IG has very limited powers. They should not be the sole source of this investigative authority. Thank you.
I thank the gentleman. Mr. Davis is recognized for 5 minutes.
Thank you very much, Mr. Chairman. Ms. O'Connor, let me continue with the focus of your work during your tenure at the IRS, because supposedly that's the reason you were subpoenaed to testify here today. When were you hired by the Internal Revenue Service?
May 30th of 2013.
And it is my understanding that you had a role in assisting Acting Commissioner Werfel in complying with the numerous congressional investigations into IRS employees' handling of applications for tax-exempt status. Is that correct?
Yes.
And according to an August 2nd, 2013 letter from Mr. Werfel to this committee, and that would be back when you were still there, the Internal Revenue Service went to extraordinary lengths to cooperate with Congress. The letter explains that the IRS dedicated, and I quote, more than 100 employees who are working diligently to gather documents, review them, and protects the taxpayer's specific information in them as required by law. Is that correct? And if so, that you have a role in setting up that process?
I had a role in advising and helping the people who were engaged in that process. Yes.
Well, thank you. Then, Mr. Chairman, I would ask unanimous consent to enter this August 2nd, 2013 IRS letter into the record.
That objection so ordered.
Thank you. Ms. O'Connor, when the IRS set up the process, what was the goal?
The goal was to get as much information as Congress and the 4 different committees and other investigators such as the IG, to get them what they needed to be able to conduct their investigations and to do it accurately and with care with regard to the redactions and as quickly as we could.
There appeared to be a lot of confusion about why the IRS did not discover the lost emails earlier. So let's see if we can clear that up. It is my understanding that it was Congress, not the Internal Revenue Service, that prioritized what documents you searched for, and Congress, not the IRS, that provided the search terms. Is that correct?
Yes, that's correct.
Well, in addition to using Congress's search terms, what did the IRS do to further facilitate the production of documents?
Among the things the IRS did was to ask lawyers and other staff people who were dedicated to things like implementing the tax laws and enforcing them to put aside their jobs and work full-time to review documents. The IRS increased the IT resources to the effort, bought servers, got additional IT resources in order to stabilize a very large system. We also, I personally, and Mr. Werfel as well, met with and talked with the staff of the investigative committees who, in addition to saying who the employees were, whose material they wanted, and which search terms they were interested in, they also had very specific requests for certain types of documents. For example, I'd like the training materials, from this period of time. things like that. And we worked hard to satisfy those sort of one-off requests, as well as getting to everybody the large body of material that was sought. And at the time at which I left, more than 400,000 pages of material, I think, had been produced. And I've read in the media that at this point the IRS has produced somewhere nearly 750,000 pages of material. And I think that it's a lot of material, and to have been able to produce in that period of time, I think, reflects a very serious effort to be able to provide what the committees were seeking in a speedy fashion.
Let me ask you, how do you respond to allegations from Republican members of Congress that you were part of some IRS plot to obstruct Congress?
Well, it's not at all true. And I think that the record of the IRS while I was there and since then reflects very, very hard work and diligence at providing the materials that the investigating committees were seeking to them.
My time is up, so I thank you very much. Thank you, Mr. Chairman, and I yield back.
We now go to the gentlelady from Wyoming, Ms. Loomis, for 5 minutes.
Thank you, Mr. Chairman. Some of our colleagues on the other side of the aisle have opined that we're getting a little off base about the attention that we're focusing in this investigation. So I'd like to focus back on some of my concerns about the failure of Lois Lerner to testify, her failure to testify truthfully about whether she broke no laws, whether she violated no rules, and whether she did nothing wrong. My concern here is if someone can come before this committee and say that, and then assert their Fifth Amendment right against self-incrimination, and then subsequently this committee finds that their own emails refute the fact that she did nothing wrong and that she violated no laws, that we should be aggressive in trying to find those emails. We already have some of them, and some of those emails suggest that she was very actively involved in violating laws. We know that she gave confidential taxpayer information to another agency, and that violates the law. We know that she specifically, while saying that it was rogue agents in Cincinnati who were involved in this, was actively involved herself in looking at, for example, Crossroads GPS, which is a Karl Rove-linked organization, Karl Rove being one of the agitators that the political left most dislikes. Here, as the Wall Street Journal editorial board writes, Ms. Lerner twice refused to testify before Congress. IRS General Counsel William Wilkins claimed 80 times that he couldn't recall events. And subsequently, it goes on to explain that the most troubling new evidence are documents showing that Ms. Lerner actively corresponded with liberal campaign finance group Democracy 21 and the Campaign Legal Center, which had asked the IRS to investigate if conservative groups, including Crossroads GPS, were violating their tax-exempt status. After personally meeting with the two liberal outfits, Ms. Lerner contacted the director of the exempt organization's examination unit in Dallas to ask why Crossroads had not been audited. I believe that Ms. Lerner was appropriately held in contempt of Congress. I quite frankly believe that Ms. Lerner should be tried for her violations, and that she should become an example that's held up to Federal employees, and especially employees in the IRS, who violate the rights of Americans in their role and capacity as public servants. And that is why I'm interested in knowing why her emails are not, all of her emails are not available. That's why I want to know why we find out just now that her email crashed. So I believe that this investigation is on the right track. It's perfectly legitimate, and I'm of the opinion that this inquiry is well placed. You know, every single night, the University of Wyoming backs up every email for the entire state of Wyoming, and every night the state of Wyoming backs up every email for the University of Wyoming, along with their own. So they not only have a backup system, they back up each other, so there's a redundant backup system for all of the emails in the Wyoming state government and the University of Wyoming, because they're reciprocating with each other. Why that kind of thing isn't happening in an agency like the IRS, where people are relying on the veracity of what's going on there to get consistent, clear rules and regs interpretation, guidance to taxpayers, and fair treatment of the people of this country, is beyond me. Now, here's my question. Ms. O'Connor, during your time so far in the White House, have you been aware of any instances of the White House reviewing documents requested by Congress under the guise of White House equities?
As I explained earlier, and I'm not sure if you were here yet, I came today to be able to answer questions about my time in the IRS, the 6 months that I was there, which is what the Chairman's letter to me said that this hearing would be about. And so I'm not prepared to talk about my other experiences today.
Now, if we were to subpoena you and ask you to talk about whether you were aware of any instances of the White House reviewing documents requested by Congress under the guise of White House equities, would you come back and answer that specific question?
Well, I've been here for a long time today, but what I would say about the issue of questions about the White House, I'm happy to work with you and the staff to see if we can accommodate and provide some of the information or what we can do. I'm happy to provide that kind of assistance to support legitimate oversight inquiries.
Thank you, Ms. O'Connor. Mr. Chairman, I yield back.
Thank you. Mr. Cummings, do you have anything further? I'm going to close, but you may close first.
Let me ask you something, Ms. O'Connor. Going back to some of Mr. Gowdy's questions, and I was sitting here trying to figure this out. I take it that you said the search terms were given to you by the committees. Is that right?
Yes.
So Mr. Gowdy made a big deal that maybe you shouldn't have used search terms. You should have just said from and to. I assume, and correct me if I'm wrong, I take it that what you were trying to do, you all were trying to do, was to get the relevant documents out first? Is that how that works? In other words, because you had the 6103 issues, you had to go through the documents. So I take it that, how did it come about that you even got the committees to even be giving you search terms? You follow what I'm saying?
I do. The volume of material, what I recall was there were 82 or 83 employees, and the way the IRS went about collecting their material was just to pull all of their emails that were on whatever computer they had, and from employee to employee, that was massive. And because of 6103, which is the law that requires the IRS to protect taxpayer information and therefore in this instance to redact taxpayer information, every scrap of that information would have to be reviewed before it's produced. And that would take a very, very long time. And in order to make it much more efficient and to get you the documents about the subject at issue, the tax-exempt organizations and their screening process and how applications were processed, we said to the committees, if you could tell us the terms you want us to use, we will zero in on the material in this vast body of information and get you the material about the tax-exempt organization process.
Now,
and the staffs were very cooperative and provided us.
And the staff knew what was going on. They knew what was going on there, and you were trying to get the information out as fast as you could that the committees wanted. Is that right?
Yes.
Now, so when you get that information, let's say, for example, you use the search terms, you call out the search term emails. What happens with the ones that are left? In other words, so you're trying to get them out, but you still got some left that might very well have information in them that the committee would be interested in, and a lot has been made of making sure that we got all the emails. So what happens then? Do they go back then and look at those? You follow what I'm saying?
So when I left the IRS, we were still producing the rolling productions of documents that had been culled through the search term process. And I don't know, other than from what I've seen in the media, what exactly they did after I left, but my understanding, just from what I've read, is that they pulled at least Ms. Lerner's, and I don't know if other people's, from the initial set that hadn't hit the search terms in order to provide them to the committees.
But do you know whether that was the plan to go back and pick up the ones that you may not have gotten at the beginning? You follow me? After the search term, initial search term?
At the point at which I left, which was midstream, the plan was to continue complying with the subpoenas. A lot of the decisions were being made just sort of day-to-day what's next, but the intent was to continue to comply with the subpoena.
No, thank you. Mr. Ferriero, you know, this whole thing of 2,000 computers crashing, we're in trouble, aren't we? I mean, in IRS, 2,000 so far this year.
As I said earlier, the state of technology in the Federal Government is not where it should be.
But that's a lightweight description. Sounds like we're in the dark ages. And I'm not trying to be funny. If you've got computers crashing 2,000 and we only half a year, and there was something that was entered into the record not long ago about services for repair of computers, the services not being needed, and apparently it said something about not delivered. There's one thing to have the money. It's another thing to spend the money effectively and efficiently. I mean, from what you've seen, are we spending the money effectively and efficiently in these various agencies, including IRS, or do we need to do something differently?
I think we're on the right track. We have, for the first time, the CIO Council and the Records Management Council working together on solutions. We've engaged the industry in developing new tools to help the agencies do their work more efficiently. So we're on the right track. And from what I just heard about your support for increased funding for IT, that makes me very optimistic.
I want to thank you all for being here. Thank you, Mr. Chairman.
Thank you. I now want to correct the record as best I can. I know Mr. Lynch will not agree with this, but he cited a number of reports, August 19th, 2013, and a follow-up report. And I just want to make it clear, our comprehensive staff report of April 7th, 2014, debunking the myth that the IRS targeted progressive groups, stands for itself, and it comes after these earlier questions. I know none of you are here for the core question
Mr. Chairman?
No,
I'll let you go. Go ahead.
It's my time. For the core questions of who was targeted. So we're going to leave that aside, and we'll let the report speak for itself. I think the paper record is fine.
I actually asked the witness, though, Mr. Chairman. I derived that information from the witness using the documents there. I wasn't relying on the documents alone. I had independent, reassurance from the witness what the document indicated. That's why I used it.
From Ms. O'Connor?
Ms. O'Connor, yes.
Somebody who had absolutely nothing to do with the underlying investigation?
No, she was actually there when the witnesses from the IRS came forward and said that they had targeted progressive groups. That was her testimony.
Okay, I'll reset the time. Ask unanimous consent. I start over then. Ms. O'Connor, what is your independent knowledge that progressive groups were targeted and treated unfairly by the people in Cincinnati, Lois Lerner, or others in Washington?
So I now can't remember the exact question, but
That's my question.
The BOLO spreadsheets had progressive and other terms on them that reflected progressive organizations.
Isn't it true they had the couple of terms that might have done it in another section, and when they looked for reconstituted Acorn, that was a criminal enterprise. That was an entity that went out of business because it was found to have committed crimes. So is that really the same as looking at all Tea Party patriots? Now, I'll ask you the question again, not a rhetorical question that we know the answer to. What treatment are you aware of to any progressive group that gave them unfair questions, hauled them over the coals as to who their donors were, whether anyone in their organization intended to run for political offices, or any of that treatment that has been specified as what conservative groups went through? What is your knowledge of that?
So my knowledge is limited, and I want to make that clear.
What is your firsthand knowledge of any of that?
My only firsthand knowledge of it is the fact that I did see some of the emails, and not all of them, that were produced in the period of time when I was at the IRS, and the email production was not complete, obviously. I didn't conduct an intervention.
So you have no personal knowledge of abuse of progressive groups or liberal groups at all. Studies have shown that there were a number of names that came up that were not all conservative patriot groups. But the unfair treatment of these groups, the 2 years and more of withholding their approval, granting them neither a yes nor a no, do you have any knowledge of that treatment or mistreatment occurring to any progressive left-leaning group?
So my knowledge is not direct from being there. I saw some of the emails. I saw,
so,
for example,
I just want to make sure I understand. Your answer is no. You do not have direct knowledge.
Mr. Chairman, the title of the report that you're submitting is Debunking the Myth of Progressive Being Targeted.
Does the gentleman have a question, a point of order?
Yeah. What's the title of your report? It says you're debunking the myth of progressives being targeted.
No, I just stopped the clock to let him go as long as he wants.
Okay.
Anything else, Steve?
Sir, my line of questioning was to counter the assertion in your report and the title of your report that progressives were not targeted. The questions to the witness indicated that progressive search terms and BOLOs were used to target progressive groups. That's the simple point I was trying to make, and I think it's relevant and I think it's admissible. That's all.
And Steve, I appreciate that. But as you know, there were additional names added sort of after the jig was up that brought additional names, progressive names in, but no evidence has been found of their being unfairly treated, which is different than a search term.
They're targeted, though. They're targeted.
Targeting.
They're going out.
Targeting for
it is relevant in both cases of the IRS intent, which is to go after certain people with certain search terms.
The IRS's intent, Lois Lerner's intent, has been well demonstrated in over 1,000 pages of multiple reports.
And it includes these progressive names as well.
Lois Lerner's intent was to overturn Citizens United, which she objected to, and her emails show that. That's what we really have. We have the President shaking his fist at Citizens United, and then her saying in public statements, they want us to do it. They want us to do it.
That is a characterization.
No, those are her words. Yeah. Ms. O'Connor, just one more time. You have no first-hand knowledge of mistreatment of progressive groups, do you?
All of my knowledge is based on having seen
okay, so written records that have been provided to this committee would be the best for both sides to put out in their reports.
Written records and the records of the witnesses that you've spoken with, yeah.
Okay. Now, we called you here because, in fact, you were at the IRS during the time in which a vast amount of documents were delivered pursuant to search terms. Is that correct?
I think you called me here because I was there for 6 months during
the time that vast amounts of documents were delivered pursuant to search terms. You've been testifying to that. I just want to set the stage. During that time, in August, because, in fact, we were getting voluminous amounts of documents based on search terms, not of our choosing, but of everybody's choosing. They just kept adding to it. And we were not getting the search, and they were being prioritized. We were getting, quote, progressive stuff seemingly first, and the minority was using it at hearings and so on. And we knew that Lois Lerner was beginning to emerge as a key figure. I issued a subpoena, and item 1 on my subpoena said all documents on Lois Lerner, all her emails. Did you have any question but that I was saying stop, at least as to this committee, both sides, stop bombarding us with documents that your organization would constantly say, we've given you 64,000, we've given you 64 million, we've given you 64 billion. What we wanted was Lois Lerner's emails, and you never went and looked for them for the rest of your time. They were not safeguarded. It was not discovered they weren't there. We asked for Lois Lerner because she became a person of interest for being the center of the unfair treatment and the deliberate effort to overturn Citizens United using the power of the IRS. So we issued a subpoena. That subpoena was very clear, and we reissued it in February. We wanted all her emails while the IRS continued to, as you said it, slowly go through these search terms, right, and deliver other documents first. You've testified to that today. They delivered other documents first, even after our subpoena was issued.
Your subpoena asked for a number of things.
It asked for, and we made it very clear in testimony and in communication, we wanted all her emails.
I understand that. The subpoena was much broader than that, and all the material that the IRS continued to produce was responsive to your subpoena as well as to the other committees. And I know it's
a question of first.
That there were many committees that were investigating, but there were. And
right, and I'm just going to close with something that I want to make sure.
A lot of demands.
Yes, I want to make sure one thing, since you were at the IRS. You said 4 committees. There's really 2 committees times 2 Congress, 2 sides of the Capitol. There's us and our Senate co-partners. There's the Ways and Means and Senate Finance. Senate Finance and Ways and Means have the ability to see all documents unredacted, right?
Yes.
Did you, in fact, as soon as you got a printout, just send it to them in bulk?
No.
No. So you applied much of that $10 million worth of time and effort going through and selecting what to give. You never gave those documents in bulk to the 6103 entities that were allowed to receive it. Had you given all of Lois Lerner's emails, looked for all of them and given them to Ways and Means and Senate Finance, then you would have known they were substantial amounts missing much sooner, wouldn't you?
Could I just address
Absolutely.
what you said? The reason that even the committees that can receive the 6103 information didn't just get massive quantities of anybody's emails is because from the beginning of the investigation, their request letters were specific. They wanted certain kinds of material. They wanted training materials. They wanted BOLO lists. They wanted emails to and from this person or to and from that person. There was a lot of very specific material, and even your subpoena, I think, identified a number of different witnesses that you wanted, and I don't believe it said only give us the first one first. That said, I did hear you in August say that you had a priority on her emails. I think I heard Mr. Jordan say that Mr. Wilkins was a priority for him. I mean, there's a lot of competing demands, and the IRS tried to balance all of that. It was really a challenge. I think at the end of the day, a lot of information has been provided, and I completely understand that it's frustrating to not get, the stuff that you wanted first, but I will say that they were doing their best to try to get a lot of material to a lot of requesters.
Mr. Lynch, did you have anything? Mr. Davis? Then I'll close with no further questions, other than a short comment. I've spent almost 30 years in business. I've gone from non-networks to PC networks to Novell networks to Microsoft networks. I've gone through Lotus Notes and Exchange servers. I've gone through a lot of technology. Today, my entire companies are run on an Amazon cloud. It backs up every day, and incrementally I can name any day for as far back as I want to go, the date, and they can restore in a very short period of time a functional copy so that I can search it. The tools exist at my former company, which is not a large company. It's a few $100 million. They exist to search the entire record of years' worth of millions of emails and millions of other factual events, invoices and the like, and do so compliant with Federal rules of discovery, because, in fact, the Federal rules of discovery do not tolerate you saying, here's paper, sort through it, or our dog ate it, or we destroy everything by simply not backing it up after 6 months. So as this committee, including Mr. Cummings, looks at holding the Federal Government and all agencies to a level, we will look to the Federal Government's own rules of discovery, the Federal Government's own rules of what we hold the private sector responsible for. I think for the archivist, Mr. Ferriero, there's no question that if we held ourselves to the same level that we hold corporate America for and the IRS holds them accountable for, we would get a very different result. The IRS, in fact, insists on direct transparency when they're doing an audit as to data and information. That's expected. And in fact, PricewaterhouseCoopers also insists on that. We have gone too long having excuses. We purge after 45 days. We purge after 6 months. We allow 90,000 disk drives that are unsupervised, including laptops, to download 6103 information and go home. Not too many years ago, we had one of the great scandals, millions of Social Security numbers of our veterans that were on a laptop that left. Reforms were insisted at that time to try to protect information. Very clearly, no one knows what was on Lois Lerner's laptop that entered and left as a portable, as I understand it, or any of these others. The protections that we expect the private sector to do, and we're handling a case right now where the FTC holds the private sector responsible if there's a loss of personal information. We don't hold ourselves responsible for. So I'm delighted, Ms. O'Connor, that you accepted our subpoena. Mr. Ferriero, Mr. Webster, I'm even more delighted that you are partners in us trying to bring a level of accountability to the Federal Government to maintain the important records the American people have a right to. And I look forward to follow-up investigations and follow-up legislation, including portions of Mr. Cummings' bill, if we can find offsets for the cost of the bill, so that we can, in fact, bring up the standards of the Federal Government in accountability. Because the American people right now do not believe or trust that, in fact, we're getting the honest answer from the IRS. And much of it is based on not getting prompt answers to questions, but much of it is based on the systematic failure to retain documents for a period of time that the American people assume that documents will always be kept at. I want to thank you. I believe this panel was unique in that it really had people that you ordinarily wouldn't see next to each other, but it played well together for a problem we're dealing with, and Mr. Ferriero, Mr. Webster, for a problem we're going to deal with together for many years. I now recognize the Ranking Member.
Thank you very much, Mr. Chairman. I just wanted to say, as I was listening to you, first of all, I thank you also for being here. And thank you, Mr. Chairman. I will be very brief. But, Ms. O'Connor, I know the IRS employees are watching this, and I want them to know that we appreciate their efforts. When I listened to what you were saying, the 4 committees and what you had to do, and these employees are working very, very hard. And I just want to thank them for what they do. And I know it gets kind of difficult sometimes, and I know you're no longer there, but you said they were working very, very long hours, hard hours, trying to deal with various priorities, getting all kinds of information from staff and trying to balance all of that. And I'm sure many of them have come under criticism, but I just want them to know on behalf of our nation, we appreciate them.
Thank you. And there's always one more thing that arrives at the end of a hearing that gets into the record, and this one is for Mr. Cummings. H.R. 1234, his bill that's been mentioned several times, has a score by the Congressional Budget Office of only $15 million for the entire government, which says very clearly that, in fact, the $10 million claimed last night by the Commissioner would seem to be an excess cost compared to CBO's government-wide score in order to meet Mr. Cummings' legislative initiative. So I look forward to working with the Ranking Member to try, and Mr. Ferriero, to try to make this a reality. And I guarantee we'll find the $15 million. And with that, we stand in recess.